Hey, out there, legal warriors, what to expect with the first-time domestic violence charge in Washington State? Is it a loved one that's been arrested? Have you got a notice to appear in court? It's tough to know what to expect and even tougher to know what to do. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. If we get arrested for a crime of domestic violence, that means there's an underlying crime, and it's involving a family or household member, and usually it's going to be domestic violence assault in the 4th degree, a gross misdemeanor crime. And if a police officer comes upon a supposed domestic violence assault charge, they're required to make an arrest if it happened within 4 hours of the time that they're showing up to investigate it. That's the 4-hour rule, and we've covered that in some other videos. But if it's not within 4 hours, they have discretion to not arrest. They can just refer it to the prosecutor. So basically, what to expect, there's two different situations we're talking about. One is where the suspect has been arrested, and one is where they've just not been arrested and they've been sent a complaint to appear in court. Now let's cover where someone's been arrested the first time. If someone's been arrested, then it's going to be a confusing situation for them and for a loved one because there's not going to be any bail where someone can get bailed out during the arrest. This recently, there was a holiday weekend, someone got arrested and they spent 5 days in jail before the court even came in to look at it, and there was no way to bail them out because there was no bail. The legislature says on a domestic violence charge, there can't be a bail until a court looks at it to decide whether or not to set a no-contact order to protect the alleged victim. Now, there can be an exception here there because courts don't always follow the rules. They have their own ways to do things, but that's what you need to think about. There's not going to be a bail where we can get the suspect out of jail until a court looks at it with a real court date or sometimes does something called paper court. What I mean by paper court, it's sort of a slang term. It means that, hey, the jail register might show someone has court on Monday, but maybe the court judicial officer comes in on Saturday and looks at the reports on their own without a real court hearing and releases people with no contact order, stuff like that, to try to empty out the jail, get ahead of things. So that's going to vary jurisdiction by jurisdiction. How you can pay attention to that is watch the jail register, right? If there's no bail or there's $1 billion bail and later it changes to $10,000 bail, well, now you'd be able to bail someone out by getting a hold of a bonding company. Again, we have a lot of videos about how bail works on this channel as well. So the big thing you'd expect if you've been arrested is you're going to be stuck there. You might be stuck overnight or all weekend, or hopefully it's not a holiday weekend, even longer. And then usually there's going to be a hearing on a court day, the first court day available after the arrest. What to expect at that hearing is if it's a city case, you're going to expect to be arraigned where a not guilty plea is going to have to be entered. If it's a felony or a non-city case, it's going to be a first appearance where there's going to be some conditions argued and set, but there won't be a plea of guilty or not guilty because the charge typically won't be officially filed yet. But at that first hearing, be it an arraignment or a first appearance, there's going to be a prosecutor, and you could expect that the prosecutor is almost always going to ask for a no-contact order, saying that the defendant, the suspect, is not allowed to go home if they live with the alleged victim, which is usually the case, not allowed to be within 1,000 feet of the alleged victim or their workplace, all these different exceptions, restrictions, not exceptions. And you need to read that carefully if that no contact order gets issued. Now, if you're the alleged victim watching this and you don't want the no contact order, you do get a chance if you can figure out how to get to the court hearing. The best way to figure that out is call an experienced attorney so they can help you figure out from their experience when court is likely to be, right? We maintain a chart of all the courts and stuff like that so we can have a good idea when court's going to be because the jails aren't picking up the phone. No one knows, right? You're not going to find that online. But you can show up and you can tell the court why it is you don't want a no contact order if you don't want one. But usually the court's going to issue one anyway because it's so immediate, right? In this example, someone's been arrested. There's a court date of the next available, court business day. And so it's so fresh, the court really feels pressure to issue that no contact order to sort of calm things down. And once that's addressed, if there's an actual charge and arraignment, the pretrial dates will be set. Hopefully the defendant gets released. If there's a first appearance, there'll probably be a second appearance date. There's a certain period of time that a county prosecutor or a felony prosecutor has to file a charge. Again, that's covered in some other videos. But basically, there may or may not be another court date. Talk to an attorney to find out what the situation is. Now, what's the second example that I gave? Well, what if you weren't arrested, or you're arrested and released, and later, months later, some could be a year later, you get a complaint to appear in court for domestic violence? Well, it's a little bit different situation. If you get that complaint to appear in court, we know it's going to be an arraignment, right? It's a first court date after a charged case. On a charged case, a prosecutor files the charge into court. The court sends you a summons. You open the nasty mail that says come to court. You go, oh my God, I thought this was over. Why am I having to go to court now? But many people make the mistake of just going to court and thinking it's going to be over right then. It's not. That's the first court date where the defendant says not guilty. And it's really important, if you're on good terms with the alleged victim now, you've made up with your husband or wife, your boyfriend or girlfriend, everything's been fine for a year, don't assume that you're going to walk into that court and the prosecutor's going to say, okay, we're not going to issue a no contact order because the case is 12 months old. I wish prosecutors were that practical, but remember, people are self-interested. Many courts, many prosecutors will still want to issue that no contact order to protect themselves, right? Because, hey, why didn't you issue the order? Right now there's been another assault and we blame you, prosecutor, or we blame you, court, for not having a no contact order. So if the alleged victim does not want a no contact order here 6 months, a year later, this hypothetical first court date, we want to make sure that they're able to come to court and say that, right, and speak for themselves. And you're going to want to talk to your attorney about what the strategy is, what the appropriate strategy is based upon the culture of the prosecutor handling the case, the culture of the court doing the case. An experienced attorney has a good chance of having a good idea of what to expect and therefore making a better game plan than just going in there blind. But once we get to that arraignment, it's going to look like the other case, right? We're going to say not guilty. They're going to set conditions, and then there's going to be pretrial proceedings, and the case will continue. So all of that to cover just what to expect at the first court date at your first domestic violence charge. If you've had more than one domestic violence charge, then we have to be more worried about having a bail issued where they demand you to post money to stay out of jail. They can do other things. They can put GPS tracking on us. They can do a bunch of bad stuff. But in this case, we're talking about a first domestic violence case and what's likely to happen. So what happens next? Well, you're going to get yourself a private attorney. You're going to get yourself a public defender. And your attorney is going to get the police report. They're going to look over the police reports with you and figure out what the evidence is, and hopefully they're going to hear your side of the story as well. And if you've watched many of my videos, you understand your side of the story matters, but not as much as sort of what we do after the fact on a first offense domestic violence case. What matters is what we do after the fact, and usually your attorney is going to have you start doing some type of educational classes or something to help improve your negotiating position. Even if we're totally innocent, we want to try to control the outcome because we don't want the jury to decide whether or not you get to go home or not, right? There's plenty of innocent people that get convicted by juries, even with the best attorneys in the world. So typically speaking, once your attorney reviews the case with you and gets your side of the story, they're going to know the culture of the prosecutor, the culture of the court, and they're hopefully going to get you started on some affirmative steps to help your case. Could be DVMRT, domestic violence moral recognition therapy. Could be anger management. We try to avoid full domestic violence evaluations. They're a little bit of a rigged game. If you ask me, it usually comes back recommending a full year's worth of treatment. Costs a ton of money, is subjective, not objective. Some courts you may need to do that. But basically, your attorney may get you started on some affirmative steps. If you do those affirmative classes or steps, is that an admission of guilt? No, it's not. It can't be used against you. It's not an admission of guilt. You don't need to do it. The attorney might have you stop. But most people that are suffering with the first offense, they've never been in the system. They want to do whatever they can to help make the case turn out without a conviction. If you want to do whatever you can, ask your attorney what you should do. And even if we're innocent, we still need to do stuff. Typically, in my opinion, there's some exceptions. Some cases are so ridiculous that I'm offended to even think about having a client do something. But from being in this system for 30 years and being a prosecutor for 7 years, I respect the power of the system and sort of how the system is arbitrary about where the power gets used. We have to make sure we do what we can to keep the power of the government away from us and away from our case. And by taking affirmative steps, we're less likely to have the full force of the government focus on us because now the prosecutor can see that you're doing some things and now they're more easily able to hear us talk about your defense. Hopefully that makes sense. I know I preach on it, but I firmly believe it. And it's what provides a lot of good outcomes for a lot of people throughout Washington State. So we can expect the case to go on. You may or may not have to attend court hearings, listen to your attorney. Sometimes the attorneys can appear for you, so you can miss less work. There's post-COVID rules. There's Criminal Rule 3.4, which many courts allow in certain situations, not all situations, in certain situations, the attorney to appear for you. But there'll be multiple pretrial hearings while you do your work, and hopefully you stay out of trouble. And the attorneys, the attorney does her work or his work, but in my firm I got a lot of female attorneys, her work in trying to figure out what the best way is to present your defense, to present your life, to present your case, if the victim's on your side, to try to make sure the prosecutor understands that and move forward with the case. The victim's on your side, does the case just go away? Can the victim have the case dismissed? No, they can't. It's not the victim's case. It's the government versus you, not the victim versus you. Now, prosecutors sort of get tone deaf that the victim doesn't want to proceed because most of them don't, right? Oftentimes it's hopefully it was a minor incident and, time heals all wounds. There's some major incidents too. I'm not diminishing this type of charge, but the most common charge you're going to see is a push, shove, something like that, although all of it is bad. But we have to understand that their wishes, if they do want to make it go away, does not make it go away, although it makes the prosecutor realize they now have more ability to use discretion without them getting yelled at by alleged victim that wants the defendant to burn, right? When the alleged victim wants the defendant to burn, well, the prosecutor's more pressure to try to, make things bad, okay, for the defendant, and hopefully time can help there as well. Eventually, you could expect there to be a negotiated resolution to the case, which might take 3 months, 6 months, a year. It depends on how serious the case is and how backed up the prosecution is and what your needs are. Sometimes we need to move it quicker if you have immigration concerns. Sometimes there's deadlines for visas and stuff like that we have to worry about. It gets very complicated. But you could expect to hopefully eventually some type of agreed resolution or a trial. Okay, trial means that you typically going to have a jury trial. It's going to be like what you see on TV. Police officers have to call them and testify. They maybe get the victim to show up, maybe they don't. But talk to your attorney about what's best for you. What you're trying to get on a first offense domestic violence, you're typically just trying to avoid a conviction if you can. Many prosecutors, you can get an SOC on a first offense, stipulated order of continuance. Not all of them. It depends on the prosecutor, depends on the difficulty of the case, stuff like that. Sometimes you can get a case dismissed outright. Sometimes you need to try to get the case reduced. Sometimes you end up being found guilty. It depends on what the fact pattern is and how much exposure you have. What you don't want to do is do not violate the no contact order while the case is going on, because if the prosecutor understands that, not only can you get arrested, but it gives them so much leverage that now our ability to help you by pushing a case to trial and making the prosecutor sort of life difficult goes away, because they can just slam that order violation on you, which is easier for them to prove if they have a good order violation, a text message, a phone call, an on view from the police officer. All those things that make your case so much harder, and it's something you want to try to avoid. So can you have consequences from a DV conviction? We talked about that, yep. Loss of gun rights, longer probation, stuff like that. Can you get a DV off your record? Yeah, you eventually can. If you stay out of trouble, you can move to vacate convictions. Although remember, you've heard me talk about records before. Nothing's ever going to be invisible. Even if you can get something off your state patrol record, the federal government's still going to know about it for immigration. Private companies are still going to know about it. Backgroundcheck.com, I don't know if that exists. It's just something I say because there's a lot of background companies. So it's probably never going to be invisible, but you still can eventually, in many cases, turn a conviction into a non-conviction, eventually with lawful behavior. But you need to ask your attorney, because those laws change from time to time. Sometimes they get better for us, the defendants. Sometimes they get worse. It just depends on who's running the government, right? So if you're a loved one watching this and you have somebody in jail for DV, remember, don't take a phone call where you talk about the facts of the case on the jail call. That's recorded. We want to avoid that. If you're talking to someone on a jail call, it is not private. You can say, hey, I'm going to find you an attorney, or hey, when's the court date, stuff like that. But please do not talk about the facts of the case. Most prosecutors sit on their bed, eating their potato chips or Cheerios, and hit a few buttons on the internet and listen to everything you ever said in the jail, right? And the worst thing that can happen that's really maddening for us is we get close to a trial and go, here's all the jail calls where he admitted it, or she admitted it, and now we're toast, right? So I think I'm going to end it there. I hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, If you have a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this for more than 20 years. We get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.